Greetings.
Hi, Mr. Howell?
I'm Nadi Ta'el, copyright trademark authorized representative of Asim Najizmar Howell, copyright trademark.
Hi, this is Department S49. I'm calling to connect you to your hearing. Hang on one second.
Yes.
Okay, can you hear me?
I can.
Yeah. Okay. Calling matter 14 and ex parte 1, Asim Howell versus Natalie People. If each of you could raise your right hand to be sworn in. Okay. You do solemnly state that the testimony. What'd you say? Okay. You do solemnly state that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
I stand affirm. I don't swear to God. I stand affirmed on the truth. What are you using to swear people in?
My hand.
No, what book are you using? What book's in front of you? You're saying you're swearing people in?
I do not use a book. I raise my right hand just as you do, and that is what you're swearing to.
Are you using a Bible though?
No, we do not use the Bible.
You don't have a Bible at the in front of you? You don't have two books should be in front to hear this case, and that's the 1611.
There's no Bible here, and we'll accept your affirmation. That's no problem.
Do you have the UN Charter in front of you today? As the magistrate, you should have a UN Charter mandatory and King James 1611. This is mandated as you are the administrator of the Ses Tuike by trust.
Mr. Howell? Okay. So let's go forward. You made a request regarding child custody, child visitation. It's my understanding that you did not attend mediation, or that you started and then you didn't complete it.
You're not very clear. The clerk is crystal clear, but you're very muffled, and you sound far, far away.
Is that better?
Yeah, a little bit. So, could you repeat what you said? I didn't clearly hear what you were sharing.
Yes, it's my understanding that you did not do mediation, that you started and then you didn't finish.
Is that's your understanding? Let me share with you the facts because it's recorded. It's on YouTube. I was at the mediation. It went for about 20 minutes. Can you hear me?
I can hear you.
Okay, because there's a lot of static. The mediation went for about 20 minutes. Joanne had both of us state who we were. I identified myself. For 20 minutes, the mediator asked questions, allowed Natalie to disrespect me, call me names, accuse me of just basically everything that she was sharing was as if it just happened to her yesterday. I let the mediator know that what she is allowing is obstruction of the proceedings. You are not to allow the other party to sit there and just share their feelings and spit how they hate somebody and so on and so forth. It went on for about 10 minutes, 15 minutes of her speaking like this. Towards the end of the mediation, I let the mediator know that I was recording because of the situation that Natalie was presenting. The mediator then stops, puts me on hold, comes back to say that she's going to end the session because she doesn't think she can identify me. This is 20 minutes in. I don't think I'm going to be able to properly identify you, and you're not supposed to be recording. I let her know that the mediation has ended. This is 20 minutes. This is up on YouTube. Matter of fact, I filed a RFO emergency hearing, which will be heard tomorrow, with the evidence of the facts, sharing that there was never a move-away order. There's never a move-away order to this day. The children have been kidnapped. Also, the attorney, Cheryl C. Murphy, which is a state bar member, she is now a judge. She was the attorney for Miss Peoples, who has an intimate relationship with the judges at the San Bernardino Superior Court. So there is evidence of racketeering. There's evidence of child abduction, kidnapping. There's evidence of extortion. The list goes on. The children do not have a move-away order, and the facts that I just shared with you pertaining to Cheryl C. Murphy being an agent of the court who conspired with the judges to attempt to monetize debt off the Ses Tuike Vi Trust of the indigenous children, which has already been established on the record for the record. Also, while I'm sharing, the United States is registered in Scotland.
Mr. Howe, are you recording this proceeding?
Excuse me?
Are you recording this proceeding?
I'm mentally recording everything. I am a record. So moving forward, you need to stick to the script. This is about the benefit of my children. It doesn't seem that you have any care or consideration for my children. This filing has been filed since February.
Mr. Howe, I sent you to mediation, and mediators will hear from both sides. I can send you back and ask for a different mediator.
I filed an RFO, a request for order for temporary custody of the children because they've been abducted. On the record and for the record, is there a move-away order? Because there's not. I would like for you to share that, though. Do you have a move-away order?
So, Mr. Howe, Ms. Peoples has sole legal, sole physical custody. So that's part of the calculation. But when we evaluate whether or not somebody has...
Objection. My honor. Is there a legal move-away order? That was my question.
As far as I know that there isn't, but I need to share with you that Judge Hopkins had ordered that you provide a up-to-date mental or psychiatric evaluation. Did you do that?
Judge Hopkins, or I have a lien on him. I have a lien on you also. And that judge told me that I'm crazy. I have that on the record for the record. That judge is incompetent.
So he said that he was not going to change any of the orders with respect to child custody job visitation until you provided a psychiatric evaluation.
The psychiatric evaluation has been admitted. The psychiatric evaluation is on the record. You have that.
Where do I have it?
The psychiatric evaluation has been filed since 2020. That, I mean, you're not.
Is it in this case or is it in the other
No,
case?
it's in this case. It's filed online. It's also published on Calamio. How are you hearing this case and you do not have the information in front of you? You're obstructing the proceedings by not being in tune with what's going on.
So, Mr. Howe, I can send you to mediation.
You've done that already.
Right, and you didn't complete it.
No. What you're saying is I didn't complete it. I've told you the facts that I was there. It was not completed. You need to, all right, so hold on and listen. Listen. You need to listen. The filing that
If you don't listen, I will hang up on you. So would you like that to happen?
what is it that you're trying to share with me right now? Because I'm trying to get visitation of my children.
I'm trying to share with you that this move-away analysis needs to be done, and that's done through mediation. So if you are willing to not record the session, I can re-refer you to mediation.
Let me share something. I am perfectly fine with mediation. I recorded the mediation because the mediator is incompetent. The fact that she's incompetent is on record. So why would I not want to record? Because this shares the truth. Don't you want the truth? Don't you want evidence? Don't you want my children to be in the best?
I do want information, and I would like a completed report, which I don't have. So what I can do is I can re-refer you, and I can ask that move-away analysis be done, and I can ask that you meet with, or I can order that you meet with a different mediator. And so that's what I'll do.
All right. Well, the orders that I had from the orders that the Ses Tuike Vi. Are you listening? The orders from Hoskins or whatever his name is, that individual. I've already honored that part of the contract. I've already done the psychiatric evaluation. I've already done all of the jumping through the hoops of fire. I've already done that. You've already extorted enough funds from me. I've already done all of what was asked. I am in honor.
So I'm going to re-refer you to mediation. The return date will be November 3rd. I'll ask for a different mediator.
Objection. I have an RFO, request for orders, that's on calendar for tomorrow. The children do not have a move away.
I advanced that so that move-away analysis can be
That's obstruction of proceedings. That's Title 18-1505. You can't do that.
I can advance it, and I did.
No, that's obstruction of the proceedings. I understand what you're saying. I accept that for value, honor, and consideration, but on record and for the record, and let the record show, that's obstruction of the proceedings. You're an accessory to kidnapping and genocide. My children do not have a move-away order.
She has sole legal, sole physical custody. I'm going to get this announced.
Objection. Objection. The United States is registered in Scotland. My children are indigenous. You're in violation of UNDRIP, ADRIP, American Declaration on Indigenous Peoples.
Your return date is November 3rd at 8:30. This is the final notice that you'll get on that date. I do need for the two of you to provide contact information to Family Court Services. Do I have your correct contact information? Still the same, yeah, still the same as it was. The email address and everything.
So where are the children right now?
Sure, that's fine. Okay, go ahead and do that.
Administrator, where are the children right now?
If people want to go ahead and provide that information.
What state are the children in?
Remember my email address, right? Okay, so I understand that Family Court Services does it by email.
They have my email. They've emailed me many times. I've emailed them every time that I file. I email them also. I email Bruce Watt, the solicitor of the Duchy of Lancaster. I email Governor Galvin. I email everybody when I do this.
All right. So I'll see, or I'll hear from both of you on November 3rd at 10:30. Thanks so much.
Question.
Bye.
Oh, you're just gonna end it like that? That's how you're gonna do it? Just keep on obstructing commerce? So there's no case tomorrow?